that evidence gives you a basis to do a computation of damage. You come in and say, ladies and gentlemen, this is the disparagement on my business. This is the harm it caused my business. You can see it right here. All right, counsel, before we begin, where are we at in jury instructions?
Your Honor, I think there's a basic stipulation with regard to the first instructions, the first general instructions. I have some more than what was proposed to me. I agree with any of their general instructions, the preface instructions. I had some additional ones. And every other instruction is objected.
Every other instruction
Is objected to.
Okay. So do I have, I guess, what I asked for? I have a list of stipulated to jury instructions.
Yeah, there should be. Well, the general ones, counsel for Franklin paired like pages 2 through 20. Kurt stipulated to some of them, but not all of them. So I guess what it came down to is he's got some proposed general ones, and it's up to the judge to either pick one or theirs. I didn't have any input on the general ones, but it seems like on the general ones, there didn't seem much disagreement.
Okay, so basically I got from Miss Anderson for jury instructions that were filed 718 and 146, which are the general ones starting on page 2.
Right.
Going through until you get basically the end of her general jury instructions is basically 20,
Right.
and then 21 begins her special jury instructions. Right. So, Mr. Harrison, my understanding that the proposed jury instructions by Miss Anderson, pages 2 through 20, are acceptable?
Yeah, I have no problem with
So
that.
I'm basically having to put together what should be put together for me, it sounds like. It's usually put together for me.
I didn't have any objection to those.
It's not a matter of objections, it's a matter of supplying the court with a clean copy that it's not
With the sources on it.
And I have the clean copy of my proposal, Your Honor, but they would rather use theirs. And they're duplicates. I sent them an email. I said they're duplicates. I'm fine with them either way. They are a little different in the wording. I do believe Ms. Anderson's are a little newer. These I've used in trial many, many times. I'm comfortable with them. I like them, but I'm fine with theirs.
Okay, so let me ask you this. 2 through 20 is acceptable to the plaintiff for general instructions? All right, Ms. Anderson, what I need from you, sent to my JEA, is a clean copy of those instructions 2 through 20, which means without citation, without any header on it, okay? That takes care of the general instructions that are agreed upon, correct?
Right, seems so.
Okay, so then what we have is plaintiff's proposed instructions that are not stipulated to, and you have a list of those, Mr. Harris.
If I may.
Wait, I'm asking him for a set of proposed plaintiff's jury instructions that are not stipulated to.
They've objected to all of them. So they're all there.
So every one of the ones, I didn't get, because those weren't filed, so I don't have a copy of them, so
I've never filed instructions.
I know they don't need to be filed.
Okay, now that was wrong.
Given to the department, so what I'm saying is, I need a copy of your general, your specific jury instructions that were not agreed upon, emailed to my JEA.
I will do that.
And that way I'll have a set of them. And then from the defendants, I have proposed jury instructions that have not been stipulated to, correct?
Correct.
And those are all here presented?
It includes Mr. Harris's as well.
Okay, fantastic.
Yeah.
That gives me a copy of that. I have every one, so that's great. Just give, no problem. I'm really not worried about you taking me on.
Oh, thank you, Mayor. We,
Never had to, I have had that happen, but
yeah, we tried to separate it with we went through conspiracy first.
okay, so what I've got, so I got the plaintiffs seek to establish liability. Whose are these that are proposed that are not agreed upon? Because they're kind of just out of order here. Okay, so the first, no, those look like yours, Mr. Needham, actually. The 3 that were here that are loose bound. It says breach of contract, and it also says in order to establish a claim of breach of contract.
Those are, I think that's all the parties together.
If there's a page number on the lower left corner, Your Honor, that would be mine.
That would be yours. Then I have another stack that looks like it starts on page 35 and goes through 54, which are, I'm sure, plaintiff's proposed instructions.
Yes, Your Honor.
Okay, that gives me a set of proposed instructions by the plaintiff that are not agreed upon. And I should have a set of, hopefully, defense instructions not agreed upon.
Those are all our instructions together. All the parties agreed to submit each competing instruction to, let's say, civil conspiracy, and let the judge decide. There's some small wording difference, see which one the court's most comfortable with, like civil conspiracy was one.
Right.
We separated them to organize them like that.
Okay.
So that we just thought it'd be easier.
So if I do it this way, you want me to go through those? What we're gonna do is we're gonna sit in chambers when we're done, and we're gonna go through all those. So I have a set that I can do, okay? Perfect, all right?
I think there might have been one missing page, but I'm not sure.
Well, when we sit and meet, which is probably gonna be early tomorrow morning.
Oh,
We gotta get it done, counsel. Mr. Harris, how long do you believe you're gonna be further on direct examination?
Maybe a half hour, Your Honor, maybe 45 minutes, because I
Okay.
can't seem to stop talking.
Okay, so we'll get done with your direct examination and then cross. Hopefully we'll be able to finish that up today, and then my understanding is plaintiff's resting, correct?
That's correct, Your Honor.
Defendant, who do you plan on calling tomorrow?
You know, I was hoping to call Mr. Sorosa today. He came yesterday and we didn't get to him, and he's back here again
Well,
today.
he's under trial subpoena, I would imagine, is he not? Is he under a trial subpoena?
Yeah.
Okay, well then he has to be here.
I didn't see that subpoena.
Well, it doesn't matter. If he's under trial subpoena, you guys can deal with that by yourself. I've got a jury sitting out there right now.
oh, you're
So
right.
all I'm worried about is I'm thinking we're not gonna get through Mr. Harris today. It might be close, but we may not get through him, or we may get through him. If in fact we get through him and he rests, then counsel, you can call your first witness. If not, then we're gonna start tomorrow. So your first witness that you plan on is gonna be who?
Mr. Sorosa,
It's really, okay, then who's your second witness for the defense?
my client.
Okay, Mr. Franklin, and then Mr. Needham, who are you gonna call?
Either Mr. Del Casal or Mr. Franklin.
Okay, we should be able to get all that done tomorrow. All right, we'll be ready to do closing on Friday. Okay, fantastic. All right, let's get my jury in here.
Yeah. I'm good, Your Honor. But we got this.
All rise for the presence of the jury. All jurors are present.
Counsel stipulates the presence of the jury.
Yes, Your Honor.
Please be seated. Mr. Harris, please take the stand. Sir, I'll remind you, you're still under oath. Counsel, continue your examination.
Thank you, Your Honor. Mr. Harris, before the break, you were testifying about a banner about Judge Marquis, admitted. Is that the banner you were referring to?
Yeah, that's true and correct copy of the banner that I saw online. It was just reminiscent of me, that the circle with the line over your face, it just seemed like a common theme. And the font's the same, and the client of Mr. Franklin's, and they talk about each other online, so it seemed very similar.
And the statements that were made on that, when the website was taken over, contained a lot of, would it be your testimony that the statements were false?
Yeah, I would say that taken in as a whole, it was false. There were bits and pieces, maybe of truth there, or truth that couldn't be proven, but statements about me, for the most part, were entirely false.
And there were statements about the business there as well.
Yeah, I would say that the statements about the business were false, probably more so false, but very false, all of them.
Do you recall how long the website stayed up like that?
I can't give an exact date. I think it was right around September 20th of, 2018. What had happened was I found out about it right around the 13th, and I was in Phoenix. We drove home, and I think Monday I prepared a complaint. I got it filed on Tuesday, which would have been the 18th of September, 2018. And then we were making efforts and attempts to serve Defendant Del Casal, and it went off the air right around the 20th. So it had been up about 9, 10, maybe 11 days.
Did its being taken down coincide with any events that occurred?
Yeah, just the attempts to make service, it had come down. as we were making those attempts. You know, we have an opportunity to speak with our process servers to see what's going on, you know, and you get information from them, and you find out that they're making attempts.
So
And
the objection order is going to get into hearsay.
Sustained.
Mr. Harris, you basically became aware that at the time the complaint was being served, is when the website came down, is that your testimony?
yeah, we were having a very difficult time getting him served. The process server was working hard because I was following up with the process server regularly, and they were struggling to get him served.
During the time that it was up, was there any noticeable impact to the business?
Yeah, just it had gone quiet, and we were having difficulty. And Cam had already been trying to get the Google page back. That took some time after that. It was like dead for a little while, but with just nothing there at all when you clicked on the little button. But we got it back. We got it back, and we got our website back online. And I would say probably maybe 2 weeks, maybe 3 weeks.
Now, in filing the complaint, did you have any hesitation in doing that, in filing the lawsuit?
Oh yeah, I didn't want to do it at all. And it's a bad idea. And I didn't want to do it. And I didn't know what else to do. At that point, I didn't know who had published it, and the only way to find out is to file a complaint. And so that's what I did. I filed a complaint, and that way I was able to serve a subpoena to figure out who was behind the rogue website that had been out there. I knew that defendant Del Casal was the author of the content. I just didn't know who he was working in conjunction with to publish it to the world.
What made you go forward?
Well, I guess it was just some of the, just all the negatives about us and the fact that, and about my employees, and then this significant drop in income all of a sudden, and them sitting around not having anything to do, and just the mere fact that it was just 100% false and offensive, and it was malicious. It was kind of this piracy of coming there and just hijacking the traffic and taking them away. And it's odd, you know, you think you go to a business and you click on that website and then it comes up with, you know, this business, don't go there. You know, that's like the last thing you'd ever think you'd see.
Now, after it went down, did it ever come back up again?
It did, it actually came back up after the filing. For some time, Mr. Franklin had it posted back up. He had some information on there, and he had information to direct those that went there to his other sites. So the website did come back up, but not by way of clicking on that box, because we had gained control of the Google landing page and every other landing page out there at that point. So we didn't have that to worry about anymore. And so if he wanted to publish things on his own little website, he could do whatever he wanted. It's just that he got back at it.
And when approximately did it go back, did that website go back up?
It was back online in 2019. We had a court hearing. I can't remember whether it was October, December. I think it was actually December of 2019. It was back online because I let the judge know at that time that he was back online, and he republished and had some different content on there, a few other things, and I just let the judge know that. They were asking for a continuance at the time, and the judge said, look, I'm not going to give you a continuance. I'm not going to give you anything.
Counsel, answer the question, please.
Thank you, Your Honor.
Mr. Harris, did you, prior to filing the complaint, did you do any investigation to try to find out who was behind the hijacking of the site?
Yeah, I did. I wasn't really, I'm not an expert in this field at all, but you can always go to whois.com to figure out who owns a website. And so I've known that from another case that I had about searching who is. So I went to whois, and I searched there, equalrightsfordivorcedfathers.com, to see who the owner was. And whois will tell you who owns that domain site, who's there. And when I got to whois, it said domains by proxy, which is this subversive secret service that you can hire to shield your identity from the website. And so I then knew that the person that was behind it was trying to hide, and they didn't want their identity to be disclosed. But I knew that from that search.
So,
Denied. We'll go ahead, counsel, finish.
Tell very clearly from the search, it was domains by proxy. It's some Phoenix company that that you can hire to be your alter ego essentially on the web.
And Mr. Harris, exhibit, if you turn to exhibit 14, what is this document?
I just printed out the search, the Who Is search. And this is a true and correct copy of the search that I conducted on the Who Is search results. And this is what I found on the day that I searched.
Your Honor, I'll move to admit 14.
Defense, any objection?
I have no objection.
No.
14 is hereby admitted by stipulation.
Mr. Harris, this is the search result.
Yeah, that's the search result. The one thing that it shows you there, it gives you the date when the site came online, which was September 11th, 2018. You can see right there. And then it was through GoDaddy was the service, but there at the bottom, you look at the registrant organization, and there you see it's domains by proxy. And that's who the owner is designated on the Who Is. Who is a federal requirement. So every website, according to the federal law, has to identify who owns. And it was domains by proxy.
Once you identified domains by proxy, did you take further steps to try to identify who is actually directing the web traffic?
Yeah, it's just interesting because I just decided to search Ernest Del Casal's website to see who his Who Is was, just because I was curious. And so I did a search immediately on the family court helpline that he had published. My son had said, hey, you should look that up. So I did look it up in Exhibit 15, essentially to verify and see who was the host of his, because I was curious. I was wondering if maybe it was the same person.
Your Honor, I'll move to admit exhibit 15.
Defense, any objection to 15?
No.
15 is hereby admitted by stipulation.
So when I did the Who Is search of the family court helpline, down at the bottom there, there it is, domains by proxy again. And it's the same host of GoDaddy as the website that was defaming me was. And I thought, well, there's a connection there, obviously. And now that I had the name and I had the address, and I had my lawsuit filed, now I could serve a subpoena on domains by proxy and ask them, who is the real owner behind this? Because then only that way can you get the subpoena to find out who is maligning you online and who's done this action. So I got the subpoena, and then I served that down there at Hayden Road in Phoenix or Scottsdale or wherever that happened to be, and they produced documents for me that Mr. Franklin was the owner.
And that's exhibit 5.
That'd be exhibit 5, is the copy of that subpoena. Or the copy of the response subpoena, I'm sorry.
And I don't know if this was admitted, but
Has not been.
I'm sorry, Your Honor.
Has not been.
Mr. Harris, when you obtained the subpoena, it came with a affidavit of a custodian of record.
Yeah, it was a certificate of custodian of record, or it was an affidavit, certificate of authenticity of business records from domains by proxy on page 3.
Your Honor, I move to admit based on the regular conducted business.
Defendants, any objection to the admission of exhibit number 5?
Yes.
Counsel, any objection?
Your Honor, I object to that. I do not see Mr. Franklin's name. Maybe I'm missing something. The allegation is that Mr. Franklin was the one who got.
We're talking about, Counselor's admission of this as being into evidence. What is do you have an objection to coming into evidence?
Yes,
Okay, and what's the objection?
that it does, the testimony is that Mr. Franklin's associated with it. I do not see Mr. Franklin's name there unless I'm missing something.
Okay, where it says here on page 4, last name Franklin, first name Michael.
Okay, I withdraw it, and I object. I didn't see
5 is
that.
hereby admitted into evidence.
Thank you, Your Honor.
If you just look at page 4 there, obviously, you can see that through the
Counselor,
page.
it's not a question, it's admission of evidence that's been admitted. Counselor, ask the next question.
Mr. Harris, this is the documents that domains by proxy sent back with the subpoena.
Yes, this is a true and correct copy of their response to my subpoena.
And on page 4 there, it's got sort of a list of information. Did you review that?
Yeah, I certainly did. With that information, I was able to discover that Michael Franklin was the owner and that MCNM Marketing was also the owner of the website, and they'd actually purchased it, and they gave me the purchase information of, it looked like it was created there on September 10th, 2018. It's a miracle we found it so quick, but I mean, it wasn't hard to discover because he hijacked our web, and so it wasn't.
Next question, Counselor.
Now that you guys, and then on the next page, on page 5, it shows the website there.
Yeah, 5 shows the website, date created, and then 6 again is like a domain information for the shopper that has Mr. Franklin's information on it, as well as MCNM Marketing, the other defendant in this case.
Once you had that information, what did you do next?
Well, my next step, once I got that information, was, look, I didn't want to sue anybody, so I sent him a letter. Mr. Franklin, and the letter essentially says, I don't know you, you don't know me, what's the deal with this? What's going on? And of course, I was a little, cranky about it, obviously. And I said, look, I just want to know who's behind this. I'm telling you, I know who's behind this, but I'd like you to inform me who it is. It seems like the right thing to do. So I sent him that letter, which is one of the exhibits in the 30s, I think.
32.
And there at Exhibit 32, I sent him a letter on February 27th, 2018, or 2019. By then I had my subpoena. It takes a little while to get through the process. I sent him a letter and essentially asked him to let me know who it was that was actually really behind it. I didn't really know him. I didn't have any beef with him. I just know that I found the information. I let him know I found it. And I was making offers to him for him to let me know who it was that was actually behind it.
Your Honor, I move to admit 32.
Counsel for defending the objection to the admission of 32.
Second letter.
It's the letter to your client dated.
The objection.
32 is hereby admitted into evidence by stipulation.
Thank you, Your Honor. And this is that letter, Mr. Harris?
Yeah, that's the letter that I sent. That's a copy of it. And just was trying to get some information. Didn't want to be here.
Did he respond to this letter?
Yeah, he responded to me on March 2nd, 2019. He responded and sent me a letter and just essentially said that, I'm just a website publisher. I don't have any control over content.
Is that Exhibit 33?
Yeah, that'd be Exhibit 33.
Your Honor, I move to admit 33.
Counsel, Mr. Franklin, any objection 33?
No, Judge.
33 is hereby admitted by stipulation.
Thank you, Your Honor. This is that letter from Mr. Franklin.
Yeah, that's the letter that he sent to me. It's interesting to note that there at the last paragraph, he essentially says, look, I'm not the author, I just posted the writings of another, he's a web designer, he states in the first paragraph. The last paragraph there just kind of stood out to me because he said, after the removal of the site, I did contact Mr. Del Casal. And I can't understand why on earth, of all the people on earth, after you took down a site, that's the only one individual that you contacted. And you contacted Defendant Del Casal. That's the guy you called. I'm not really sure what that was all about. Then he asked him if he knows the customer, this Phantom he cooked up. No, apparently nobody knew who the Phantom was. But that, he says that Ernest informed him he'd sold the business name years ago. And Mr. Franklin knew when it was sold because he said he was there and he walked out and hadn't been there since. So it was just a lot of misrepresentations. I didn't really know at the time. I didn't know him at all. I didn't know why he.
Objection, all right. You need a question that gets taken the narrative.
Sustained.
In this letter, did he admit to being the publisher of the website?
Yeah, he very much admitted to being the publisher.
Did he state in there that he verifies the information that he puts out?
Yeah, he said he verifies all content before he publishes. And that apparently he put it up there for customer review. Why does anybody need to go to the
Objection.
Google landing
Well,
to?
But if he's going on it, the question is not why did he do what he did, it's not why, it's going on and on and on, but there's no question as to that issue.
Call for a narrative, sustained. Council, next question.
Mr. Harris, did he indicate in there that he simply posted it so that the customer can review it?
Yeah, he indicated he only put it up for review, but he redirected my website there for the public when they went to the Google landing. That's why I just knew immediately, it's like, you're just full of it. Because if you wanted to put it up for a customer review, you would tell the customer where it was, and you can go see it there on a non-public forum. You don't go to the Google listing and make a full change and misrepresent who you are to redirect all traffic over there to this phantom.
Now, did he say that the website was only up or in this letter, does he indicate how long?
Yeah, it's been the repeated theme throughout these last almost 4 years of litigation, that it was only up for 12 or 24 hours. That's just not true. I would not have filed the lawsuit days later if it had come down after 24 hours. That's just false. That's a lie.
Have you ever, I believe you testified yesterday a little bit and mentioned Nevada business list? What is it?
Yeah, Nevada business list, I also, when we searched on that, we found out that he'd put the publication on this Nevada business list, something I'd never even heard of, but I don't know if that was, it was just his effort to get it out there to as many eyes as he possibly could.
And is that in Exhibit 70?
Exhibit 70 is a true and correct copy of that Nevada business list page that I believe Mr. Franklin owns.
And when was that posted?
I
I believe it says right there under the.
Yeah, the exact date. September 18th, 2018, so the day that I filed the lawsuit, he posted this on the Nevada business list. His prior representation was it was only up for 24 hours, but here 4 days later, he's posting it on this Nevada business list, and this is a true and correct copy of that post.
And the next page in there, on 70-002, what's that document?
That document is not related to the Nevada Business Post. That was a document that was Michael Franklin Jr.'s Facebook page that showed Ernest Del Casal as one of his friends, but was not related to the Nevada Business List. That first page is the only one with the Nevada Business List.
Did you pull a copy of this off of his Facebook page?
Yeah, there's a true and correct copy that I pulled off of the internet. When I searched Michael Franklin, I came up with this Nevada Business List.
Your Honor, I move to admit 70.
Yes.
Your Honor, I did assert an objection previously.
Yeah, but still with them as individuals, 70-001, do you have any objections to that portion? That's the Nevada business list Facebook page.
I don't have objection to number one.
Okay, Councilman Sanderson, do you have an objection to 70-001?
Yes, yeah, again, I see that the business is referred to, I do not see Mr. Harris's name anywhere. Can you point me to it?
Mr. Harris's name as far as being on this, it's not. All they're asking for is that this page that shows Nevada business list, equal rights for fathers, pretends care, and then the direct site to that web page, that this page be admitted. Whether or not Mr. Harris's name on it's irrelevant. The question is whether or not this Facebook
You're right,
page is being admitted.
just for the record, that the equal rights for divorced father, not a plaintiff in this case.
Okay. So do you have an objection to this being admitted? Relevance is your objection?
That's it, Your Honor.
Okay. Overruled. 70-001 is hereby admitted. Now dealing with 70-002. Mr. Needham, your objection.
The objection was misleading because it, as you can see from the exhibit, Mr. Harris did a search under Friends by putting in the first name E for Ernie, so it would pull up in alphabetical order, and it basically give the impression like, it gives a misleading impression, and then Del Casal popped up. So our objection was it's misleading and kind of a pre-selected evidence, so it's a misleading document.
That it doesn't show the entire list of all of Mr. Franklin's friends?
They did a search where Mr. Del Casal's photo comes up.
Because he is a friend under Mr. Franklin's Facebook, otherwise it wouldn't have shown up, Counselor.
No, the order of it, the positioning of Mr. Del Casal, the positioning has been elevated because it is searched specifically under E, under which is Mr. Del Casal's
Right,
first.
so it's basically, it's only the pages that start with Ernest. You can see an Ernie and Ernest and Ernesto. You're saying that it doesn't represent all of Mr. Franklin's friends that would pull up on the pages.
Well, it was not a random, they got to where Mr. Del Casal would show up first, so that kind of give an impression, like, it gives a misleading impression, that's my objection, because they did a search. I want to put that on the record.
Yeah, 70-002 is hereby admitted with the jury's understanding that this was a direct search under basically the preference for Ernest, and that's why Mr. Del Casal's name came up first. Was not the fact that Mr. Ernest Del Casal is the first and only friend of this individual. Okay, next.
Thank you, Ron. This is that posting on Nevada Business List?
Yeah, that's the posting. It just redirected you over to the equalrightsfordivorcedfathers.com that Mr. Franklin had set up, and it just took you over to that same webpage you saw this morning.
And then this is the friend list showing that they were friends.
Yeah, I was trying to tie the two together after I'd gotten the response from the subpoena, and I was able to, I already knew, but I just wanted to confirm they were friends on Facebook.
And that's Mr. Del Casal on the.
Yeah, that's his profile.
And that response from Mr. Franklin to your correspondence, I should have asked you this before, but was there any offers to give you back access to the?
Yeah, he essentially said that he bought the website legally and lawfully, and that I could buy it back from him if I wanted, and this could all be resolved. Not sure if that was in the first letter he wrote me or the second or both.
Well, here, it's 33. For sake of clarity there on like the third.
Exhibit 33, it's already been admitted, right, Counsel?
Yeah,
Correct?
that's.
Is that what you're referring to?
Yes, Your Honor.
Okay.
Yeah, I mean, it just tells me that if it's the customer never paid him, the spam customer, it's available at this time. We transferred, if you want to purchase it, contact me by phone or email, and I'll let you know.
Now, did you respond to Mr. Franklin?
Yeah, I took another run, just trying to resolve it, really. So I sent him another letter on March 15th, 2019, just in hopes that maybe we could just derail this.
And that's exhibit 35. Your Honor, I've moved to admit.
Counsel, the defendants, any objection to Exhibit 35?
May I see it?
It's the March 15th letter.
Oh, no objection.
35 is hereby stipulated into exhibit.
This is your response to Mr. Franklin.
Yeah, again, I just let him know that things were defamatory, what he'd said and what he'd done. And it was hurtful and harmful to others, and I didn't know him and didn't understand what it was all about. By then, I knew that he'd had some connection with George, and I kind of asked him about, if he verified content. Why did he say those things about this person? I just there at the last paragraph of page 2. I was very clear that, no, last paragraph, we only seek cooperation in this matter. I know Del Casal is the author, and I did, and I do. And he and you will deny this. He apparently prefers to allow you to take the blame and the financial responsibility. I was really just trying to get some cooperation and be done with this.
Did he then respond to that?
He did, fired back, and he actually wrote me again another letter, very kind. And that's exhibit 34.
I'll move to admit 34, Your Honor.
Counsel, any objection to Commissioner 34? It's Mr. Franklin's letter back.
No objection.
34 is hereby admitted by stipulation.
And what does he essentially say back to you?
Pretty much the same thing as before, he does say that, I've already filed an amended complaint at this time, and I let him know that I have an amended complaint, I'm gonna add you as a defendant in this case, but we can avoid that if you just let me know, because I'm not eager to sue you. But he kind of took that as, well, you've already filed an amended complaint, so he'd been in contact with defendant Del Casal, and he knew what I was brewing, and I was just trying to avoid it. And then he just essentially said that it could legally be, that he legally purchased it, and if I believe someone stole it, I could take it up with GoDaddy. He just kind of let me know that, but there at that kind of second paragraph there, he says the domain name belongs to me legally, and I have already offered for you to purchase it. And once you purchase the domain name, all of this could be over. And that sounds a little extortionistic to me, for someone who's well aware of the word there. That's kind of a banana. And then he just went on to say again that it was up for 24 hours, which is untrue by his own testimony and by his own actions from that prior exhibit we looked at, where he was publishing it on the 18th of September on his Nevada business list site. So it was just fake and it was just false what he was saying. And we knew that at the time, we'd already seen it. But he just said he didn't author it, wasn't him. And I did question him about contacting Mr. Del Casal. And he wants to know, why wouldn't he? I'm being linked to a case in which you were suing him, which he couldn't have really known that, I guess, unless they were talking. So, I mean, it was pretty clear to me they were working together.
Now, after this, did you continue, were there continued postings or reviews online that were occurring?
Yeah, funny thing is, it just didn't really stop. And to some degree, it really became, Mr. Franklin became much more active with his posts, but we were still getting negative reviews, just like we kind of had been, but they were getting taken care of.
And Exhibit 37, Mr. Harrison.
Yeah, Exhibit 37 is one of Mr. Franklin's posts on Nevada Court News, the same thing that Mr. Casal owns. And he was making a post about me at that time. I believe it's in 2019.
This is in August of 2019.
That's correct.
Mayor, I believe we previously admitted this.
Well, there's
a document similar.
a new narrative.
This is a different document, so.
Okay, Mr. Harris, you obtained this from Facebook group?
I downloaded this off of Mr. Del Casal's site. It was a post that Mr. Franklin had made on that site.
Okay.
This is a true and correct copy of that download.
I moved to admit this one.
Move to admit exhibit, Counsel.
Sorry, it's 37.
Plaintiff proposed 37. Defendant, any objections to plaintiff proposed 37?
Could you tell me what it, I don't see the date on the sketch, could you, what the date is on that one?
The date of the post is August 8th, 7:29 a.m., according to the page itself.
Thank you.
Any objection, Counselor?
Oh, yeah.
37 is hereby admitted as evidence.
What year was that?
Mr. Harris testified. Mr. Harris, what was the year on that?
2019. The only thing I really want to show real quick for the jury is then he starts attacking and saying, you really need to clean up your character, your business will grow. Everyone reads reviews now, businesses, so he knows very well what he's up to and what he's doing, and he's just informing the whole world. Everybody reads these reviews about you, and what you do, your reviews show about you, and so, and then down below he's got me with I'm a frivolous attorney seeking out suits to extort money, when in fact I did everything I could to avoid this suit with him, and he was extorting money from me for the website, but that was where he was coming from.
Mr. Harris, if you turn to Exhibit 38.
38 is a true and correct copy of another post made by Mr. Franklin on this defendant Del Casal's webpage in reference to my business. That post was made January 22nd of 2020. And it was in regard, this is a true and correct copy of that.
Your Honor, I move to admit, proposed exhibit 38.
Counsel for the defendants, any objection?
Let me see that.
The only objection I would have, Your Honor, it doesn't seem to indicate whose Facebook page this actually is.
It just says go to google.com, review of equal rights for divorced fathers. That's all he's making a statement, is it directed him to this point. Not that they directed or misdirected anybody.
I thought I heard that somebody posted on Mr. Del Casal's webpage. That's what I thought I heard.
No, all I heard was this was a posting on this page.
I have no objection.
Okay, 38 is hereby admitted.
I think really about this, I want to say is that obviously he's posting about my business, that's my location, but he just says this is a recent review that they didn't pay for. And the implication there by Mr. Franklin is that I paid for reviews. And that's defamatory in and of itself, that's just a lie. He's saying, I have never paid for a review. Now I know that he does reviews, but I have never paid anyone for a review, ever. That's just false.
Mr. Harris, if you could look at 41.
This is a true and correct copy. That's a continuation of that posting that we just talked about a little bit about Mr. Franklin and on Mr. Del Casal's site. And this is just in addition to more posting and that was going on back and forth between the two co-defendants. This is a true and correct copy of that dialogue and exchange from September 22nd, 2020, around that time frame.
I'd move to admit proposed exhibit 41, Your Honor.
Counsel for the defendant, any objections to 41?
Let me see. I have no objection.
Okay, 41 is hereby admitted to stipulation.
Just there on page 1, I just wanted to point out these two individuals, they kind of comment back and forth. And Ernest had made some reposts, because they post and they repost, and it's almost like it's new information, but it's really old information. It's just this continuous posting and reposting of negative things about people. But Ernest there posted the case number for the case that we're here for today. He posted that on Lousy, Las Vegas Lawyers, and some judges, I don't know what that is, but he posted that there, and then he reposted it here with Michael Franklin's assistance. There at the second page, that's that Michael Franklin took to the airwaves, I guess, on October 30th, 2020, and wanted to let us all know what defamation was. So apparently he wanted to educate the public on what is defamation. And then just moving on between the two parties there at the third page, 41-003, that's the post we just already referred to where he alleged that I was paying for reviews.
And then exhibit 42, Mr. Harris, if you could take a look at that.
Yeah, exhibit 42 is this is a true and correct copy of a Facebook posting by Ernest Del Casal regarding me and my business, and that he had made during the pendency of this action.
These are accurate copies.
Yeah, these are true and accurate copies that are downloaded off of his webpage.
Your Honor, I move to admit 42.
Let me see that.
Your Honor, this, the objection has 8 pages, and some of them, maybe which stipulated that some seem questionable. So
Which page do you have questions about, Counsel?
I think that it's beginning with page 3 looks different than what's been identified.
Page 3 looks
Looks like
different.
okay.
I'll get to this, I don't know whose it is. There's no reference to Mr. Franklin there.
Mr. Del Casal.
This is done with Mr. Del Casal right now, Counselor, that's what we're doing.
We're just looking at the rest of these, I think we need to be able to stipulate all of
Okay.
them. We don't have no objection to this, Your Honor.
Okay.
So 42 is hereby admitted into evidence.
Mr. Harris, this is the posting by Mr. Del Casal.
Yeah, I just wanted to show the jury that he was having a dialogue with this individual, I guess his name was Emmanuel Guevara, and they were talking about the differences and the changes in the business, and apparently Mr. Guevara was not happy. But there at page 2, Ernest goes on to state there at page 242-002, the same language that you've heard throughout the publication, that attorney Kurt K. Harris, use my full name there, Kurt K. Harris runs it, his stepson, there we go again, Cam and Scott Caterer run the place by themselves. They let George and Arturo go, which is 100% untrue. We never let anybody go. And you heard George testify to that yesterday, that he wasn't ever let go. I don't know if he's still there. And then he goes down below and says that they're suing him because one of his old clients went there and ended up writing negative reviews like this, so they blame me instead of themselves. Now, at this point, Mr. Del Casal is admitting that it's one of his old clients. So apparently he knows who this phantom is as well, because he's identifying him as an old client on this post. He's never come forth and said who this so-called old client is. And so I'd be curious to know. At page 3, he reposts some other posting from an individual who I don't know. And I could not find his record anywhere on in my firm files.
Ryan Whitney.
Brian Whitney, yeah, I'm not sure who that individual is, and was not available, couldn't find any information on him. And this is taking place on September 28, 2020. On the next page, on 4, again, he's posting another review about me. He seems to be very active about posting these reviews that he's digging up and finding. I think Kevin Holiday may have actually been a client and was not happy with how things came out. Sometimes you just can't help everyone. Those things can happen without disclosing anything about what I know of his case. We could not help him. Then at page 5, same thing, he's posting another old review about a Joseph C. I don't know who Joseph C. is. I don't think he was ever a client of the office that I'm aware of. Without his last name, I probably could never run him down anyway. But Ernest was reposting these posts about me. It's interesting to note there's a picture there that he submitted. That's a very old picture, and it's not been on the door since I've been there. So the review could have been from the time that Ernest was there that he's posting about where Joseph C. was dissatisfied. I don't really know exactly as far as the dates go. And then finally at page 6, there's another post that I believe is directed towards us. On page 6 at the bottom, that Ernest is still active in posting, or defendant Del Casal, I should say, that if you're a lawsuit and you prepare documents for family court litigation, but you do not put your name on it. We put our name on pleading, so I don't know that he's referring to us. He's probably not. But he's talking about ethics and a few things. Finally, last page 7, another post that Ernest has reposted from Nason, and I never have had a client named Nason. I have no idea who that is. I don't believe that to be a true post, but it just goes on. During this litigation, there was just a lot of posting and kind of this obsession with posting reviews about me.
Sheriff, if you could turn to 71. And it wasn't just Mr. Del Casal reposting reviews. Mr. Franklin join in as well?
Yeah, Mr. Franklin did. There's a trunk copy of a posting that he made on Mr. Del Casal's Facebook webpage, Family Court News.
Your Honor, I move to admit 71.
Counsel, is there any opposition to admitting 71?
May I see time to look at this? seemed to be a review by somebody. You know,
Counsel, any objections to the admission of 71?
I just need this foundation.
Okay, so relay that, he said this, he pulled it off of Mr. Ernest Del Casal's Facebook page on the time in which it's presented. It's a true and correct copy of the page that he took it off of, that's the foundation, so what's your objection?
No objection.
71 is hereby admitted.
This is the post by Mr. Franklin.
One of the many posts by Mr. Franklin. This time he's basing it, and he says that, you know, it seems that they're all racist now, which I assume he's basing an opinion, I think that's an opinion, based on an opinion from this Google review by Jessica Hernandez, who was never my client and is not a client of the office. But, you know, that was one of his posts, and then the business should never have been sold in his opinion. And that is his opinion, he says his opinion. But I think it's unfortunate, and nobody likes to hear those kind of accusations about themselves.
Returning to 72.
Uh, 72 is another posting by Mr. Franklin on a different forum. This is on michaelfranklinjr.com. That's the other website that he set up. This is an article that he posted, a new article, and it was posted on July 31st, 2019. This is a true and correct copy of that article that he posted online.
I moved it.
That's it. John, I think this is part of the website that has been admitted before, so it's duplicative.
It is part of the portions of it. In regards to review, do you have an objection to this portion of it? Counsel, any objection to this portion?
Is this the duplicate since already there in the records?
72 is hereby admitted.
Right, Mr. Harrison, this post, did Mr. Franklin, I guess, narrative change in any way?
Yeah,
Very
he's,
hard to- let me see if I can zoom in.
sorry, I don't know, it's very, I had a hard time, it's very small print. He's launched into a whole new bold area now, a whole new arena. It has nothing to do with the old post. This is all his words, his language, his posting, and his statements of fact and of opinion, predicated on nothing but just his gossip and false statements. But then he just launches right into me on this caution buyer beware, and that the extortion of money, which he knows what that is. And then he just goes on with me on this narrative about things that, talking about these people were complaining, these unnamed, unknown individuals that he speaks of, and some common knowledge of things that are just untrue. And then he just says we're operating under the disguise of 702 dads. And he knows exactly who we are and what we are. And then he goes some of the same language of luring fathers and sending people essentially into court without representation.
It says here now that he's been approached by several people.
Several now, yeah, it was growing at that time, and yet I did the deposition when I put him under oath. He couldn't name several. He barely eked out one that he said was an Aaron, but he couldn't give me a last name. Just some guy.
And does he state here that he believes these statements are true?
Yeah, he states they're true.
And what's his basis for that?
Well, I guess he thinks that it's truth based upon reviews on Yelp.
And that he's a business owner.
And he would know, he's a business owner, he understands that there are those reviews out there, I guess. And then he actually reposts again this Ryan person who, again, is not a client of my office, to my knowledge. And they certainly didn't name him or bring him in, so I don't know who that individual is, and I have no way of really finding out.
He accuses you of being involved in corruption and fraud.
Yeah, I think those were the harshest words, fraud and corruption. Obviously, again, nobody wants to hear that, but a business being involved in fraud and corruption can be very harmful and very damaging to a business. It really is, it's defamation per se. The damages there are presumed. That's business reputation and corruption and fraud. Nobody wants to be involved in that. And those are not stated as matters of opinion.
Does he in here state that the business is failing?
He did. I thought that was odd. He mentioned that the problems were that the business was failing or something, or that I'm trying to cover for a failing firm. I'm not really sure. But that would not be the case. Doing all right.
Does he accuse you of wanting money from Mr. Del Casal?
Yeah, that I'm just seeking for money. That's all I want. That's all I ever wanted. And nothing could be further from the truth. All I ever wanted was just to be left alone.
If you could turn your attention to 60. What is Exhibit 60?
60 is a post on Michael Franklin Jr.'s his personal Facebook page. And this is a true and correct copy of that, where he posted on his Facebook page how to go and find the posting we just talked about and looked at, and giving people instructions on how to go there and providing links on his Facebook page on how to go to what his narrative just was.
I'll move to admit 60, Your Honor.
Counsel for the defendants in the opposition to 60.
No objection, Chair. I'll withdraw a second.
I'm sorry, Madam, I didn't hear you.
No objection.
Thank you, counsel. 60 is hereby admitted into evidence.
And that's just it. It just talks about it talks about extortion and frivolous suits. This is the same thing you've already seen. But he's just continuously on the posting. You just can't leave it alone. And this is during the court case. So,
And he mentions that you have a losing or a long record of losing in frivolous court cases.
yes. I don't know. I don't know how to address that exactly. I don't, nobody likes to lose, and I don't think I have a long record of necessarily losing. I don't know anything about frivolous court cases. I've never tried to really file anything. I've never wanted to file anything frivolous. We sign our pleadings according to Rule 11. To the best of our knowledge and ability, there's something behind them. We can back it up when we file a pleading. And again, he acts as though I pursue these suits, and nothing could be further from the truth. He thinks I pursued this suit against him somehow, and he's done all this filing. Somehow I'm the aggressor or something, that I pursue these suits. When I don't want to be here. I'm not seeking this out.
Did you say in here that you seek out cases?
That's the only page there. Yeah, essentially that I seek them. I'm looking for them.
Or you seek out frivolous lawsuits to extort money?
Yeah.
Did he ever tell you how much he wanted you to pay him to make this all go away?
No, he offered this for sale to make it all go away. So I went to GoDaddy to see what the cost of it was. He wants $50,000. I don't have $50,000.
If you turn to Exhibit 18.
Yes, another posting by Michael Franklin on his Facebook page. It's a true and correct copy of that.
I'll move to admit 18, Your Honor.
Can I see that?
This one's dated in June of 2019.
Hold on, counsel's looking at it.
I have no
No objection.
objection, no.
18 is hereby admitted.
What is Mr. Franklin saying in this post?
Well, it's kind of the same old posting thing you've always seen over and over, and I apologize for that. But he does bring up the First Amendment. He invokes the First Amendment at that time without really having a very good understanding of what the First Amendment says. And we looked at it during my opening statement. You know, the First Amendment is it's about the government curtailing our speech. But he says there below, as a matter of fact, at the bottom there, that I'm attempting to silence, or up above there a little further, it says it seems Kurt K. Harris, got my full name, is attempting to silence my client and take away their right to speak freely due to the fact that if people learn the truth, and he goes on and on, stating it as a matter of fact, that if people are going to learn the truth about me, that they're not going to come to me, that they're not going to work for me. And he speaks of this client, this phantom again, which he won't identify, and he can't produce for you or me, that now I'm trying to silence this mythical friend of his, or person, or client, whatever it is, I don't know. He goes on in the next page. It's more of the same about me trying to silence him, but he intends to bring this to court. And he states as a matter of fact, he's not gonna allow me or the courts to bully him about this unlawful and unethical business practice. Stated as a matter of fact, not as opinion. He plans to see justice.
Does he insinuate in there that you also break the law?
Very clearly states that me being unlawful and unethical, that I'm breaking the law. He doesn't state what it is I'm doing to break the law, but he's making a statement of fact that I've broken the law, that I'm unlawful and I'm unethical.
Sorry, I just didn't know.
Thanks.
There's two parts in the end. Can you look at exhibit 26? What's this document here?
26, another one of the many posts by Mr. Franklin on Mr. Del Casal's website, where he has now posted a poll and he's seeking information. There's a true and correct copy of that posting.
I'll move to admit that.
Counsel for the defendant, any objection to 26?
The only objection we have here, I'm not sure what site this is being posted on. They reference Ernest Del Casal, but I'm not sure if it's Ernest Del Casal's site.
On the bottom, it says Ernest Del Casal shared a link, and all he was making references that this was taken from Mr. Del Casal's website. Mr. Franklin had posted on it.
Patent objection.
Okay. 26 is hereby admitted.
Mr. Franklin's now creating
Yeah, he's made a poll.
surveys or
Yeah, he's created a survey or a poll. He's trying to get some information. He's trying to find out some things about me. We're in the middle of the litigation, and now he's just looking for people to vote. I'd like to know how they voted. I'd be interested to see that. He didn't release the results, but he is looking for somebody to testify real hard. Now, you would think if he knows who the Phantom are and he knows all these people, he doesn't have to set out something and publish it to the whole world looking for that. But he's doing the best he can to find someone to testify against me.
and he didn't identify anybody that actually voted on this?
No, I couldn't.
Sir, if you want to look at 47.
Yeah. This is a true and correct copy of a post I found on Google.
Counsel, hold on a second. Counsel's approach.
All right.
Counsel, you're acting as a witness.
Mr. Harris, you issued some there was some written discovery that was issued directed at the defendants in this case, is that right?
Yeah, I had sent them information, a request for production, and request to admit. I was looking for some information about the case and trying to ask them a little bit about, trying to get some background, trying to get some information.
And Exhibit 57, is that a copy of request for admissions? There are answers from defendant Del Casal in response to your request for admissions.
Yes.
First, Your Honor, I've moved to admit these.
Counsel in opposition to the admission?
Sure, what's the number, please?
57.
Is this defendants, this Del Casal's or Franklin?
Yeah, they're Mr. Del Casal's on your
No
letterhead.
objection.
Okay, 57 is hereby admitted.
Mr. Harris, if you can just real briefly explain what a request for admission is.
Well, we send out these requests to admit where it's kind of a leading question that we ask where we'll send out a request to admit, say, I want you to admit this. Admit that you were at your house that particular night. Admit that you own a blue car. Admit that your dog is named Fred, or whatever that happens to be. And so we send those out to individuals with a preformed thought process of what we think they're going to say, and then we send that over to try and see if we can get them to admit that as a matter of law. And that goes on back and forth between lawyers throughout discovery.
Now, in this case, you had sent these over to Mr. Del Casal, and he responded. And what did you ask him in request number 11?
Well, 11 specifically, I was trying to get at, I'm trying to get the connection between him and Mr. Franklin. I'm trying to understand what their connection is or why they've conspired against me. And I'm trying to establish that for the court and for you. And so I make that request, and admit that you're an acquaintance. Just trying to figure out, are you an acquaintance of this guy?
And what was his response?
Well, his response was that many years ago, he was a past member. I mean, it's just really strange because you're talking to each other, you're hanging around with each other, you're commenting back and forth online together continuously and constantly. You're friends on Facebook, you're calling each other, and yet it was just some guy that used to be a member of the group. He was just very evasive, and that was just kind of the answers that you got. That's what I was getting. Stonewalled everywhere.
You also sent some interrogatories.
Yeah, it's part of it.
Those are in 58.
That's Exhibit 58, yes.
I move to admit, these are defendant Ernest Del Casal's answers to your interrogatories, correct?
That is correct.
Counsel, Mr. Del Casal, any objection to 58?
No objection, I'd like to have just some dates put on.
58 it was electronically served on 5/1 of 2019, and that seems to see also the declaration of your client on the same date, 5/1 of 2019, Counselor. Okay. 58 is thereby admitted by stipulation.
And, what did you ask him there in interrogatory 14?
14 specifically, I was just trying to get the belief about the publication and the information that was contained in it, whether it was true or false. I was asking Mr. Defendant Del Casal, is this true? Are these things true that are published here? I'm not saying that he published them in this request. I'm just saying, are any of these things true? And his response to me is that it was vague. He didn't my question was too vague. Couldn't understand it, couldn't respond.
Do you know if Mr. Del Casal continues to use the equal rights name?
Yeah. As a matter of fact, he continues to use it as his web address, which is odd for his personal email, one of his personal emails.
And what is that email address that he uses?
I think it is EDRDF or something at Gmail.
Is it ERFDF?
ERFDF, there it is,
If you
ERFDF.
wanna look at, exhibit 63,
Yeah, 63 was a pleading that was filed in this case.
Hold on, sir. Are you trying to admit this, or are you just asking him to look at that to refresh his recollection?
I'm gonna move to admit it in a second.
Okay. We'll lay a foundation for that.
Mr. Harris, what is it, exhibit 63?
I'm gonna object to this.
What's your relevance, Counselor?
That his last known email address as listed by counsel is listed as the Equal Rights for Divorced Fathers of Life.
Okay, so I don't think they're disputing that, seeing as they put in their own documents that Mr. Del Casal used at least on 9/28 of 2020, the email erfdf@live.com. I don't think they're disputing that he used that. Okay, move on, it's not admissible.
Did you ever ask in the depositions or in any of the, well, at any point, did you ask Mr. Franklin whether or not, similar to Mr. Del Casal, whether or not the information was true that, or he believed it to be true?
Yeah, I've asked Mr. Franklin that in the deposition. That's the only conversation I've ever had with the man. You know, what basis he had, if any of it was true, or if he had anything to suggest that it was true. I served discovery saying, you know, if you have something that would indicate that any of this is true that you published and continue to publish, and he stated that he had nothing. He doesn't have anything which would suggest to him that any of the statements are true.
And did you ask him if he felt that they were his opinion?
I don't recall exactly whether I did or didn't.
Now, we've gone over in extensive detail a lot of the postings and the redirection of the website. Have you had an opportunity to, I guess, quantify what harm it caused to you as a business?
I've really tried to be fair and try to figure out what the business is over the life of a client, whether you lose them or don't lose them. You've heard some testimony about that yesterday from my son.
We're gonna check as to, there's never been any copy
Approach.
documentation.
Jurors, please stop from the bench. Ladies and gentlemen, at this time, we're going to take an early brief recess in regards to this matter. During this recess, you're admonished not to talk or converse among yourselves with anyone else on any subject connected to this trial, or read, watch, or listen to a report of or commentary on the trial, or any person connected to this trial by any media information, including without limitation, newspaper, television, radio, or the internet, or form expressing any opinion on any subject connected to this trial, the case is fine submit to you. You're not to do any experiments or investigation regarding any matters raised in this trial, nor to post on any social media forums about the trial, or attempt to investigate anything you heard in this trial using any form of social media, internet. We'll see you guys back here at 5 minutes till the hour. For the youngins, that's 2:55. If you want, I can do it in military time if you'd like. Mr. Harris, start digging for that document. Whew. You guys back here in about 10 minutes. I want to see the document in regards to disclosure. And Ortega requires a computation of damages. It does not require anything other than that. You're thinking of a medical malpractice and or PI case where you have to have bills and such, things like that. Here, the individual can testify to it is the plaintiff. It's also the manager.
We have things about special damages like loss of
That's
property.
true.
That's what we're talking about.
We're talking about damage to reputations. He can testify to it.
You want me to dig for it now, or gonna?
I'm ready to dig for it. I want to see what you disclose, Counselor.
Okay, Your Honor.
Come to order. Court is back in session.
Counsel, approach what we have. That's what him to approach.
That's all, sorry.
I should just see what he's gonna present to me.
Page 4 and 5 and 6.
Okay.
They should be highlighted.
All right, so I have basically on a disclosure, Mr. Harris's office in the dispute, well, this would be actually the original JCCR. Or at least the list says computation of damages. Plaintiff alleged the defendant has breached a contract which damages are computed to have a value of $25,000 to $40,000. In addition to the breach of contract, it is alleged the defendant is liable for libel and other allegations which could potentially invoke punitive damages for business interference and wrongful conduct. That's on the first one. And on the next one, that's dated 1/22 of 2019. Basically, it's the exact same statement as far as breach of contract. So counsel, so you got a computation of damage for the breach of contract that I will allow, and basically your son testified and you testified as to what you paid for it. In regards to the next section, what you basically said is my damages are, looks like punitive damages only. Of course, other than if in fact you have a defamation per se.
Well, it's stated
not
there,
gonna
the
be
libel is the defamation per se, Your Honor. And,
Okay.
and the business,
Interruption. or
yes,
interference.
as well as the defamation towards the business. Disparagement, that was the word I was fishing for. But I will say, in addition to that, Your Honor, that these were produced, and the motion that Mr. Needham filed said that he never received a computation of damage, which was completely false. Because he did get those, he got both those. As a matter of fact, he signed off on the JCCR. And he never conducted, neither side conducted any discovery, never asked any questions about damages, no depositions, no discovery, no nothing. I understand your comment from Monday, they don't have to. They don't have to. But they can't show up here today and say, we didn't do any discovery, we didn't do anything, and now we're just somehow caught flat-footed.
Okay, but here is the thing, is under Ortega, the plaintiff is required to give a computation of damages out, and your computation of damages says, based on the breach of contract, I have a value between $25,000 and $40,000, so that's a range of a breach of contract, you can understand it could be a range, and I can deal with that. So that gives you the computation of damages for the breach of contract action, don't have a problem with that. For the other causes of action, other than per se, which is assumed damages, that's the definition of per se. We assume that if you find libel and or defamation per se, the damages can be assumed. But in regards to the damages for what you call the business interference and wrongful conduct, disparagement on that, what is going to be the computation of damages? Where is the computation of damages that was disclosed to the other side in regards to that cause of action?
Well, it was testified to by Cam yesterday morning as far as our
Where was
loss.
the computation of damages in discovery as to that portion of damages?
I do not have anything that would indicate that in discovery, in all honesty, Your Honor.
Okay.
Was never asked either.
Well, it doesn't have to be asked, it's not their burden. Your burden is to prepare a computation of damages for the causes of action that require a computation of damages. For example, general versus specific damages. For example, in a PI case, if you get in a car accident, you go see a doctor, that's a specific damages. You then claim general pain and suffering, that's a general damages. We don't actually quantify that because there's no way to quantify it. We leave that up to the jury. But when we're dealing with breach of contract, we know what the elements of damages, and you've done a good enough job. Here's computation, I'll allow that. When it comes to the intentional interference and disparagement of business, what is the damage to the business?
Well, in my mind, Your Honor, I'm going to say, quite frankly, I thought that was a jury determination because these
Based on
damages.
what? What are they gonna base it upon?
They base that on, I don't know how they base that, to be quite honest.
Based upon evidence. Your son, Cam Harris, as the office manager, comes in and says, here we go, ladies and gentlemen, here is 5 years or 3 years of our business. We bring in 15 or 30 clients, like you guys said, 30 clients per day, on average, $5,000 per client, that's $15,000 per client. Right here, this is our average, 25, 30, 35, 40, 25, 22, however varied it goes. Here's how many we sign up. Here, look at this time period, when the release of this disclosure came out, to the time that we think that it got pulled back, whatever time period that is. Look at this dip, ladies and gentlemen, here you go. We didn't sign 30, now we signed 6. Then we signed 2, then we didn't sign any, then we didn't sign any. That evidence gives you a basis to do a computation of damage. You come in and say, ladies and gentlemen, this is the disparagement on my business. This is the harm it caused my business. You can see it right here. Here's the drop in the revenues. That's evidence.
Well, we
So
have
it's
to
required
test
in
that,
regards
Your
to those claims and those causes of damage. But in a per se, a defamation per se, it's presumed damages.
Well, that was where I guess that's where I'm at on far as the damages is the per se. And all the case law seems to tend to state that you can't necessarily compute it. the value of a reputation.
That's true, and that's why the reputations and the per se's are automatically presumed. If someone damages your reputation, that's why we have, they used to be called pantomime. We actually used, in fact, as one of the attorneys in here in town still uses that when he represents gamblers. I think Mr. Needham's even done that in front of me, where if you cuff someone on the floor, it's automatically presumed defamation per se. That you automatically defame them, because if anybody sees someone else in handcuffs, we automatically assume criminal. They don't even have to allege damages in there, other than saying, I was placed in handcuffs in a public place and I was falsely arrested, therefore I have a damage or a defamation per se. It's by pantomime. Actions, no words. Just the cuffing of someone is damages. Those cases are fine. We allow those. That's what defamation per se is. When you're talking about these forms of defamation, you got those. When you're talking about disparagement on the business, you have to have evidence that shows this is what caused the damage to the quote business itself, the underlying dollar figures that we lost. It harmed my business, it damaged my reputation, per se. You harmed my damage by saying this, I'm no longer a valid attorney. Then you can come to the jury and say, ladies and gentlemen, I can't quantify it. That's up to you to quantify it. Those are per se damages, you can do it that way. Okay, so I will allow you to testify in regards to the breach of contract and the per se damages. We haven't gotten to punities yet, so we'll deal with that issue when we get to those.
Your
Okay.
Honor, may I make a couple points on that?
Points on what, on my statement?
No, based on the computation, I don't believe there has been a computation damage, which is why under that 16.1A, it says category. So like when I see breach of contract, someone will say, was it a lot of wages, was it something, this is not a, you don't do a computation of cause of action, you do a computation of damages.
Correct.
So my position is, in terms of special damages, because that's what we're talking about, I understand you don't have to compute pain and suffering and general stuff. We're talking specific about special damage, which breach, we need to know what type. And not only
What was the
that,
contract for, Ms. Counsel? What was this contract for between these two parties? What did they purchase?
business.
Okay, so does not that define what the quote damages are?
Not in my mind, we don't know what the breach is and what the damage
Okay,
is.
we know this isn't a UCC one, we're not talking about equipment that was destroyed, we're not talking about loss of rent, we're not talking about something like that, we're talking about a business that is I think even your client will admit, 100% based upon goodwill.
You know what else?
People come in the door because of goodwill.
And I also think there's been this is so many years ago, this computation, almost 4 years ago. And there's been no supplements of this computation to put the defendants on to any kind of sort of computation whatsoever. So my bottom line position is I don't think it's fair to any defendant in this particular case of not getting any kind of notice of what the damages are. We have a duty under 26 to supplement your discovery.
And he's saying he's 25 to 40, and counsel, I understand your issue about it is might not be very specific in regards to that. But Cam Harris yesterday testified in his opinion as office manager how many people normally come in a day, and that depleted off that time period. That's enough evidence. People don't understand that testimony is the best evidence. You don't have to have a piece of paper if you have witness testimony. That individual testified. That is enough for them to get over the hurdle to say that they have at least established in their mind damages, and this individual is able to testify to that. Okay, I'm allowing the portion on the breach of contract in regards to any other phase that it's not per se. There's not going to be any statements in regards to damages. They're not going to be computed.
And just for the record on Cam, on that note, we do bring a motion to strike that testimony, and I'll put it in front of you now.
On what basis?
Just based on what I just said, based on my position, I'm asking that if the court wants to deny that, it's fine. But
I don't understand what the actual motion is. You want to now strike a witness who you already
not
sat
a
here and
witness,
listened to
just
him?
that portion of his testimony as to the damage based on.
Did you object to any of it during the time of the questioning?
No.
And you waived it.
Okay.
Okay, let's get my jury in here.
Your Honor, just one other point of clarification on two matters. No evidence on punitives at this time.
You don't ever get into punitives until you actually get past
So,
me to get it to the jury. Then if the jury says there is in fact malicious conduct here, then they get to hear about the financial well-being of these individuals in order for us to get there. We don't even get there until they find punitive damages.
Second point I wanted to raise, I didn't know if you had an opportunity to review the video of the opening where Mr. Needham had indicated that I had done enough as an attorney to settle this case and I hadn't undertaken
I
steps.
haven't had a chance to look at that yet. Trust me, yesterday I spent my entire time trying to catch up on motions that I have to hear today and tomorrow.
Understood, Your
And I
Honor.
will try my best to get through your opening tonight.
If I could just reserve the ability maybe to retestify on that, if Your Honor has on the additional steps I took settle the case, which we try to stay away from.
I will look at that.
Thank you, Your Honor.
Thank you. Let's get my jury in here.